ॐ सहना भवतु सहनौ भुनक्तु सह वीर्यं करवावहै तेजस्विनावधीतमस्तु मा विद्विषावहै ॐ शान्ति शान्ति शान्तिः। We welcome all the participants on the second day of our IKS-TKDL workshop on traditional knowledge, intellectual property, and people's rights. Today, we are very honored. We have with us Madam Dr. Vishwajanani Satyagiri and Sir Anil Kumar Sir, Mr. Anil Kumar, the senior scientist of CSIR TKDL unit. So we just want to inform you, please don't send any message regarding the assignment after the session. We'll upload the link in the Google Drive and in the chat box. And before we start, we'd like to give a brief introduction of Sir, Mr. Anil Kumar. Sir is working as senior scientist at CSIR Traditional Knowledge Digital Library Unit at New Delhi. At CSIR TKDL unit, he is responsible for intellectual property prosecution, traditional knowledge, and related assignments. Before joining CSIR TKDL unit, he has served one of CSIR laboratory at Kolkata, that is Indian Institute of Chemical Biology and headquarters. He has extensive experience in intellectual property rights and technology management, as well as traditional knowledge. With degrees in biotechnology, management, business law, along with experience as an advocate, he brings a broad and dynamic perspective to his work. He is also served prestigious organizations such as Indian Council of Agricultural Research, Biotech Consortium India Limited, and National Research Development Corporation in various capacities. Today, Sir will talk about the fundamental aspects of intellectual property rights with some important case studies. So I request Madam, please say a few words before Sir starts.
Okay, thank you so much, Piyush. Good afternoon to everybody. Namaste. Welcome to the second day of the IKS Division CSIR TKDL Unit Workshop on Traditional Knowledge, Intellectual Property Rights, and People's Rights. So, what's the point if it's not audible? I think, Dr. Shweta, if in case we are not audible, you please disconnect and connect again. I think we are audible to each other. I'm not sure if in case there is an issue only at your end. Please log off and log in again, please. And use your earphones if in case the system is not responding very well. Okay, yeah, so I get a nod from many others that it is audible. Thanks so much. So yesterday, what we tried to do in the workshop is to kind of give you a glimpse of the Indian knowledge systems. Professor Murthy gave an elaborate talk on the subject matter, followed my own presentation on the traditional knowledge expanse and diversity and the uniqueness of the Indian traditional knowledge, and the traditional knowledge being a dynamic subject matter needs to adhere to whatever are the requirements and resources available at that point of time to meet the needs of the time as well. And in today's context, because everything that we do, we would like to gain credit for all the work that we do, the intellectual property rights become very important. So in today's workshop, the session that we are going to have at the workshop will be focused on the fundamentals of intellectual property rights. So following this, because once you have a clear understanding of what intellectual property rights are, you will be able to better appreciate and understand the intellectual property rights in the context of traditional knowledge and what entails the rights as well. And when we are talking of traditional knowledge, I mentioned yesterday, there are two major categories. One is a codified traditional knowledge, which is public information, public domain information to everybody. So it is a shared subject matter, say shared knowledge with one and all. But when it comes to the second category, that is the oral traditional knowledge, we are talking about, people's knowledge, that is the custodians of such knowledge are the individuals of the community. So there is to be this particular subject matter of oral traditional knowledge needs to be handled very carefully with a lot of respect to the people, the community is involved. So there is the subject matter of ethics that comes in. So you'll get to hear more about, traditional knowledge in the context of these two, that is intellectual property rights and people's rights in the next 2 days. So today the platform is all yours, Anil. So you please, give your overview of what intellectual property rights are and what entails, seeking such rights and grant of such rights. Thank you so much. Thank you, Piyush, once again.
Thank you, ma'am. Piyush, should we start?
Yeah, just 1 second. I think, Piyush, we need to also reiterate that the link for the MCQ test for today will be given after the end of the talk. Okay, so please click on the link that is put in the chat box. Everybody is supposed to take the MCQ test because these marks add to the total scores on the 5th day. So all of you, please follow the link that will be shared only after the end of the session. For now, please focus only on the discussion. Do not put any other subject matter in the chat box. Do not distract others. Do not distract yourself. Please pay attention to the lecture. Thank you.
Thank you, ma'am. To start with today, so yesterday we had a introduction of TK, how we consider TK and what exists in our history. So today's topic covers the intellectual property rights aspect. So we'll be going to discuss. I'm audible, Piyush? Yes. Okay.
Yes.
So we are going to discuss the fundamentals of intellectual property rights. So before I start, let me share my presentation. Is the presentation visible to you, Piyush? Can you please confirm?
Yes, it's very clear.
And it is moving also?
Yes, it's moving also.
Okay,
Yes.
thank you.
Yes.
Thank you.
Thank you.
So when we talk about intellectual property rights, these rights are basically given for the original creation that has come out from the intellectual of the creators or authors. So these intellectual property rights, they may come out of the scientific creations, the artistic creations, or for literary activities that we do. So today we are going to discuss about various forms of IPR and the instruments that are available for protection of these rights. So as you all know, this is the 5th workshop that is going on. It is joint workshop between IKS and TKDL, and you all have already registered for this, and we are into the second day of this workshop, which is basically dedicated for IP rights. We'll also discuss some specific case studies also. Okay, so this session will be of around 50 minutes, which will be followed by the question answer session, and then in the end we'll have an assessment, a short assessment, wherein a link will be shared in the chat box, and all the participants, they are requested, it's mandatory to attempt those questions because they will be a part of the final assessment as well. Okay, so this is the broad outline of the activity that we are going to do today. So to start with, let us first understand how these intellectual property right tools they help in creation, protection, and exploitation of the intellectual creations. So we all know that the cost which is attached to the research and development has gone very high. And when we talk about development of new product or process or any intellectual creation, apart from the investment that it requires in terms of the labor, the manpower and other resources, the cost of placing that product in market is also very high. So combining all these aspects of intellectual input that is required, it becomes very imperative to protect the creation for a certain period of time, during which the creator or the author of that intellectual creation can reap benefits out of it, so as to compensate the investment that the person has made. Okay, so it's a kind of circle wherein you invest some labor, some resources to create something, then you get a protection for limited period of time. For example, if you see this product, it is a patentable product wherein you can get right for a certain period of time, which is 20 years from the date of the application. Okay, and once you reap out the benefits that you have invested along with a degree of profit, then those benefits can be further used for creation of a new product. So it's a kind of cycle. It is almost established cycle wherein these IP tools are being used for the benefit of society. Okay, so during the presentation, we are going to discuss about copyrights, patents, trademarks, industrial designs, geographical indications, and plant variety protections, apart from other instruments that are available for protection of IPRs. So these rights, they are basically domestic in nature. Domestic in the sense that each country, they have their own IP laws. Although these laws across the globe, they are having basic similar standards, but they differ in some angle or another because they are basically amended to suit the requirements of the domestic industry or the people, according to the need of the country. Okay, so we are going to discuss about all these tools of IPR one by one. So to start with, we'll first understand what are patents. Basically, patents are granted for the technological innovations that we do. Okay, and when we talk about the technological innovations, that can be a product which gives a solution to a problem, or it can be a process that delivers a new way of doing something. Okay, so patents basically they are granted for two, product or process, and it attains the technological development that happens. With regard to the requirements, basically, as I already told, they can relate to process or product or both. And the essential requirement that is needed for getting a patent, is that they must be novel in their existence. So to understand the novelty, the novelty is established when the technological invention that is claimed in the patent application is not published or used anywhere in the globe. Okay, so these laws are domestic. The rights may be domestic, but the novelty aspect is global in nature. For example, in case we are filing a patent application in India, so once granted that those rights will be enforceable in India. However, when the examiner is assessing the novelty, it will be global. So something which has already been published outside India will kill the novelty of your invention in case it is already disclosed there. Okay, so the invention must be novel in its nature. Additionally, in case you are doing some improvement, improvement over the existing invention or some product or process, then it must have an inventive step. Okay, so inventive step is like you have done some incremental advancement over the existing thing, and the most essential thing is that the invention that you have claimed in the patent application should be industrially applicable. Okay, and more so, once the patent application or the invention that you have filed for registration qualifies all these essential parameters, that invention must not fall under non-patentable subject matters that we will discuss in the second slide. Okay, so to see these all aspects, if you see the cycle with this rowing mechanism with it, so in case we file a patent application today for this invention, it lacks novelty because it is already published in the year 1900. Okay, so there is no novelty. However, if we talk about inventive step, in case we make some changes some incremental changes to this bicycle with rowing mechanism, so that a person who is skilled in making these cycles will require some additional efforts to do, I mean, to make those changes effective, then it has an inventive step. Okay, so this is how the essential requirements for getting a patent are fulfilled. So if we see the purpose of getting a patent, it is very clear that it promotes technological innovation and it gives a fair a time to reap out fair commercial rewards during the term of the patent, which is 20 years. And if you talk about the disclosure, so once you file a patent application, it must be disclosed in a way that after the expiration of this patent, after 20 years, a person who is having ordinary skill in that technological domain must be able to work out that invention without any additional efforts. Okay, so the disclosure must be sufficient enough to work it. So it's a kind of arrangement between the public and the government that you disclose the invention fully and you get the right on whatever you have disclosed. Okay, so that it should come in public domain after the expiration of the patent. So if you see the statutory definition, it imbibes all the essential ingredients that we have talked. It says invention means a new product or process involving an inventive step and capable of industrial application. Okay, so these are some of the examples wherein, I mean, the patents can be granted. So if we talk about apparatus, devices or machines which fulfill all the essential parameters which we discussed, they get a patent. Okay, chemicals, they are also patented. We can get a patent over drugs, food or their compositions. In fact, the biological processes which have no human intervention in them. So something which is discovered on its own is not patentable. However, in case we do some human interventions and come up with a new biological process which is in a way effective and having which fulfill all the essential requirements, then that is also patentable. Likewise, we can get patents on biological products, then processes are also patented. These are some of the examples which I have given, which are basically patented. Okay. So in the first slide, we discussed about about non-patentable subject matter. So if we see section 3 of Indian Patents Act, it says that although the invention fulfill all the essential requirements, but in case they fall within these exemptions, I mean the list provided under section 3, then they are not patentable. So they are excluded from being patented. So some of the examples that have been given there is like, in case you're filing a frivolous invention, okay, you're filing a patent application for frivolous inventions, then it is not patentable. In case you say that I have developed a machine which has 100% efficiency, for example, the input which we give comes out completely, please, then that is not possible. We know it under scientific principle, that is not possible. So something like that, which on the face of it, that I mean states that it is frivolous, then it is not patentable. Likewise, if something is against the public order or morality, or it causes serious prejudice to human health or human health, or it is causing harm to human, animal, plant life or environment, then that is also not patentable. Likewise, discovery of scientific principles or discovery of living things or non-living things, that is also not patentable in nature, in case it is existing already existing in the nature. So these are some of the examples wherein discovery of new form of known substance is also not patentable. Then subsection E says that mere admixture leading to aggregation of different properties of element, substances, are also not patentable. So likewise, the methods of agriculture, horticulture, and then the process of surgical, curative or diagnostic or therapeutic processes, they are also not patentable. Then plants and animals in whole or any part of them, okay, other than the microorganisms, they are also not patentable. They include seeds. Then we have mathematical or business methods, software which are not patentable. Then copyrighted subject matters or design protected matters, they are also not patentable. Okay, so scheme or method of mental act or playing games is also not patentable. Then most importantly, the presentation of information, the information, the way we present the information is also not patentable. Additionally, then we have a separate law on integrated circuits Therefore, it is also not, these integrated circuits, they are not patentable per se. So most important thing that we must understand is like in our patent law, the traditional knowledge or aggregation of known properties of traditionally known components are also excluded from being patentable. So when we talk about traditional knowledge per se, or in effect, in case we file a patent application, which in effect is traditional knowledge or aggregation of the known properties, then Section 3P of Indian Patents Act excludes patenting of such inventions. So this is very important when we talk about traditional knowledge. Okay. Apart from that, I mean, there is Section 4, which excludes atomic energy inventions from being patentable in India. So this was all about the patents, and this is the process for getting a patent right. So the office which is competent to entity in the patent applications and grant such rights is the office of PDTM. They have offices across India, and for Delhi we have a patent office in India. Okay. So in case you want to file a patent application, you can draft the patent application either provisionally or complete and file it in the patent office of Delhi. So once we file that patent application, it is published within a month in case you want to get it early publication, or it gets published after 18 months in its own course. So once it is published, then you have to file a request for examination. So once you file the request for examination, then only these applications are being examined by the patent office, and all the essential requirements that we talked in the first slide, they are being assessed by an examiner in the office. So they look whether all these essential criteria required for getting a patent are fulfilled or not. Okay, and once it fulfills the basic requirements and it qualifies for getting a grant, then a patent is granted, and you have to renew those patent applications annually. Okay, and these are some other provisions that are existing. So in case you came across a patent application which has traditionally known components being claimed in it, then the person who has an interest can file these pre-grant and post-grant applications. And in case it is granted, then you came to know about those applications, then they can be revoked also. Okay. So these are some of the provisions that I thought we should discuss. And with regard to the rights which are given, in case you get a patent for a product or process, then you get the rights for 20 years to make or to offer that product for sale, or you can import that product in India. Okay, you can do it in case you are the owner of the patent, or you can get an authorization from the patent owner to perform these activities. Okay, but in case you are not having the rights to do that, then you are infringing over the rights of a patent. Okay, so you may infringe a product by doing such activities, or you may infringe a process also in case you are using that process or offering that process on sale, or you are just importing products which are being manufactured by the process. Okay, so these are some of the activities which basically lead to the infringement of patents. So if you talk about the infringement of patents, they're basically direct or indirect. Okay, so direct infringement is like when you completely copy the claims of a patent application. So if you see the patent application, it has a portion which is known as claims, wherein the rights are written. Okay, so in case your infringing product is having the similar elements of what has been claimed in a patent application and it directly matches, it is like a direct infringement. Okay, and in case it is very same, then it is literal infringement. And in case, although they are not same, but they are performing same function in a same way, then it is also a direct infringement under the doctrine of equivalence. Okay, and when we talk about indirect infringement, there might be an induced or contributory infringement wherein somebody else, he has supported in the infringement. So these are some kind of activities which we must understand when we deal with the patented products, or in case we have a patent, to see whether somebody is infringing on our rights or not. So this is the second IP tool that we have. So this is like, we all have heard about copyrights. Okay, so it's a right, it's an intellectual property right given to the authors of literary works. Okay, and it is given for artistic, literary, dramatic, or musical works. Okay, And the purpose of granting these rights is to encourage creativity. And the whole objective is to promote creativity and to benefit the author so that he may continue with his literary or the artistic activities that they are doing, and they can reap out the benefits from the efforts that they have made during creation of those intellectual outputs. Okay, and as we discussed in patents, these copyrights, they also have a limited time to enjoy, and all these rights, they basically regulates the use of the copyrighted matter, how they must be published, how they must be distributed, and the way they are utilized by general public. Okay, so when we talk about the copyrights, basically some of the examples that are given in this slide, they are copyrightable subject matters. So the books that we write, they are protected under copyright. Then the paintings, the art, the dramatic work that we perform, the musical creations that we made, they all are protected under copyright law. But the essential ingredient that we all must understand is that the protection of copyright is given to the expression of ideas. It is not given to the idea itself. So in case you have something in your mind, which once expressed can form, intellectual creation will not get protection under copyright law until or unless you express it in a tangible form. So the expression of idea is the basic requirement. To take some example, we all know that the Ramayana or Mahabharata, they have been, they have been expressed in different forms. So we have certain books wherein, they have been depicted. We have certain movies wherein, they have expressed. So the idea behind all this is same. Okay, the story, the screenplay, everything is same, but the way they have been expressed are completely different. So in case you express something in a different form, then you get a copyright over the expression, which is original in nature. Okay, so originality is one thing, and expression of ideas in a tangible form is the essential ingredient. So it's very clear that the protection is given to the expression of ideas, not ideas. Okay, and when we talk about copyrightable works, they fall under three categories. First is like they are, the literary, dramatic, musical, and artistic work, they are the original works. So the essential requirement of getting all these copyrightable subject matters registered is that they must be original. They must not be copied from somewhere. Okay. And there are examples given, like literary, we have poem, story, novel.
Namaste, sir. Have you got disconnected? I can't hear you. Madam? Namaste, sir. Can you hear me?
Am I audible now?
Yes, yes.
Yes, I can hear you. Am I audible?
Yes, yes.
Am I
Please
audible?
continue. Please
You can
continue.
see my slides also.
Yes, yes.
So I
Please
was
continue.
talking about, sorry for the technical,
No problem.
this thing. So I was talking about the copyrightable works. Okay. So the literary, dramatic, musical, and artistic works, it got connected. Yes. So I was talking about the copyrightable works. So the original works, like literary, dramatic, and musical and artistic works, they must be original in its nature. It means that the items must not be copied from somewhere, and the expression is original in nature. Okay. But for these cinematographic and sound recordings, we all know that for creating a cinematographic film, there must be a combination of literary work, which is the script. There must be some dramatic elements. There must be some music also, and there must be some artistic, elements put in. So combination of these original works will lead to a specific copyrightable subject matter, which can either be a cinematographic film, and it can be a sound recording also. So the requirement of originality in true sense is not for these two items. However, all the remaining items, they must be original in their expression. Okay. When we talk about the rights which are granted under copyright are like the owner of the copyright, he gets a right for reproduction. Okay. So he may decide the forms in which this creation can be reproduced. He can regulate the distribution of the copies of the work. He can also regulate or control the public performances made out of the work. He has also the rights to regulate or to control the broadcasting activities. He has also a right to control the translation of the work that he has done into another languages. And the last right that he gets is like adaptation of work. This is like in case there is a novel written by an author and somebody is interested to make a movie, then this kind of adaptation, this is adaptation of the copyrightable subject matter. And for making a movie out of novel or vice versa, you require a permission from the author of the copyrighted matter. Okay. And the rights are basically three. So first is like you can get economical benefits out of the rights that you have. So those are falling under the economical rights. Then you have moral rights also. So moral rights are like they are a part and parcel of the rights under copyright law, but they can't be shifted to the subsequent owner. They remains with the author. However, the author can very well waive those rights. So there are three kind of rights under moral rights. First is like the right to attribution. He can claim the right over his own, the materials that he has created, and he can stop the derogatory use of his work. Okay. And these are some of the rights which falls under a moral right. And lastly, the performer, like somebody in case he is acting in a movie. Okay. So they have a performer's right also, wherein they get certain rights to utilize them. Okay. And like patents, there is infringement of copyrights also. So when we talk about infringement of copyrights, we have certain measures wherein we can prevent those. So these can be civil remedies in terms of injuncting the person. We can say, we can restrain somebody we can restrain them in copying or infringing our rights. We can ask for damages. We can also ask for cost or accounts. Okay. And apart from that, certain acts under copyright law, they are criminal in nature. They're cognizable. You can be fined or you can have some kind of punishment for those acts. And there are certain administrative measures also to see whether somebody is infringing or not. So after copyrights, we'll talk about trademarks. So basically, on daily basis, we see a lot of marks or lot of marks which are being used by various companies to promote or to represent themselves. So if you see some of the examples that are given in this slide, if you see this M of McDonald's, or you see, the color which is being used by Pepsi to designate their products, these are the trademarks which are routinely used by these companies to just indicate the source from which that product is coming. Okay. So these marks are basically marks being used for branding the products. And basically they indicate the individual or business from where the specific product is coming. And these marks, they have a goodwill attached to them. That's the reason they becomes very important. And protection of these marks becomes very imperative. Okay. So when we talk about the marks, they can be either word, design, they can be signs, they can be symbols, they can be shape of certain goods. Okay, the kind of packaging we use also falls under trademarks. The color combination that we use, and apart from that, some smell marks and the sound that comes. That sound which is being used to identify a certain product is also registered under trademarks. Okay. So these are additional marks that are, that shows that what kind of marks are being used. So if we talk about the protection of trademarks, basically the term of protection which is granted for trademarks is 10 years, which can be further renewed for next 10 years. So unlike patents, they can be renewed till you are using that product. Okay. So this is like, in case you want to use it for 50 years, you can renew it after every 10 years till you are, interested to use those rights. And apart from, additionally, these rights can be licensed. You can license the right to use a trademark. You can completely sold it out by way of an assignment, or you can partially transfer the rights to others. Like in case you want to license a mark in certain jurisdictions, some of the specific states you want to give those rights to somebody else, then that is also possible. And in case you want to make up, you can dispose the rights completely, that is also possible. So this is one of the examples that I have taken from the Kenya, the country Kenya, wherein these baskets, the producers of these baskets, they have used trademark law for their benefit, and they have created an immense goodwill and standards of quality using those trademarks. So if you see these baskets, they are being cultivated from the fibers of sisal plant, which is cultivated there. And by the collective effort of this community that has, come up to protect their right, protect their brand and the trademarks law, they have just created some specific standards. Okay. So in case you talk about this brand, okay, which is a trademark, the consumer in his or her mind directly, relates to the quality standards that they have created. So in a way, they have imbibed the quality standards in the trademark. Like in case you come across this product, you directly trust the producers, and you can, you can be assured that, and you remain assured that the basket will have a certain kind of quality which is established. Okay. So they have used the traditional knowledge for the benefit of the society, using a tool which basically is for branding, but they have imbibed the essential requirements of the quality parameters also. So we can get motivation from such kind of examples to promote traditional knowledge based products for gains. Okay. The other kind of IP tool that is available is industrial designs. Industrial designs are basically, these rights are given for the appearance of the products. So basically 2D, two-dimensional or three-dimensional appearances of the products, they are basically protected under industrial designs. So when we talk about the two-dimensional or three-dimensional aspects of a design, they can be a shape of a product. Like we can see the shape of this bottle, different kind of bottles that are shown in the presentation. So each bottle, it is having a different shape, which is, and each shape can be protected under industrial designs. Apart from that, the configuration, the surface pattern, they are also protected under industrial designs. The pattern or ornamentation on these articles. Okay. So if we see the pattern of the design that has been put on this shoe, it is also registered under industrial designs. The composition of lines or colors, in case they are original in nature, they can be protected under industrial designs. So for getting a design registered under this law of industrial designs in India, the basic requirement is that it must be applied to an article. Okay. So in case I apply same kind of design on a shoe or different element, I mean article such as I mean a blanket, then I can get protection for that same design on shoe and blanket separately. So this is like the essential parameter is like that design must be applied to an article. Okay. And this is probably due to the reason that putting a design to this shoe becomes very difficult, although the efforts required to put the design on a blanket, they are completely different. Okay. So you have to just adjust the motifs. Okay. So you can't blindly put that design to a shoe. You have to do certain kind of intellectual efforts to make it more appealing to the consumers. So this is the reason why it must be applied to an article, and applying the same design to two different articles makes both the articles qualifying to be protected under industrial designs. And another thing that is essentially required is like it has to be applied by a industrial process. Okay, it can be a manual, mechanical or chemical process. Okay, and the another thing that is required is like that a protected design must have commercial or industrial value. Okay, and one thing that is very important to understand with regard to industrial designs is like that it must, I mean, the rights, the right given under this tool is limited to the visual appeal of the article. It doesn't give any protection to the functional parameters. Okay, so it's like whatever you can visually see is protected under the designs law. And when we talk about the originality characteristic of industrial designs, then this is the definition which is given under section 2G, which says in relation to designs, it means that it is originating from an author of such design and includes the cases which, though old in themselves, yet are new in their application. Okay. So if you talk about what is not registrable under designs is like something which is not seen by eyes. So we have a watch which has something, I mean, we have designed the internal parts of the watch which are not visible by our eyes. Okay, so then those articles, those elements of the watch are not patentable. Although in case we have a watch which has a glass covering, and we can easily see the interior of the watch, which is designed in a way that it is original in nature, then the protection can be granted for that also. That is the reason that only the visible part which can be noticed are protected under industrial designs. Okay, something which is not visible or noticeable is not registered under industrial designs. And likewise, buildings and structures, they are also excluded from being registered under industrial designs. Then part of an article which is sold separately. Okay, so when we talk about article, it has to be a commerciable article. Okay, so we can't say that we have designed something which can't be sold separately as an individual article. So something which can be sold separately, which can't be sold separately, cannot be protected under industrial designs. Then variations which are commonly used in trade, they are also not registrable. Then stamps, labels, tokens, medals, trademarks, cartoons, they are also excluded from being registered. And additionally, mere change in size of a known design, that is also not registered, because you can create different sizes of one item. So you can get registration for one single item only. Likewise, emblems, flags of nations, they are also excluded, and computer chip and integrated circuits are also excluded, just because we have a different law to cover those things. And if we talk about the duration of designs, there basically the registration is given for 10 years initially, which can be extended by another 5 years. So this was the duration of the designs. So now we'll talk about geographical indications. So basically these are the signs or marks or indications which are being used to designate the origin of a specific product. and the origin of that specific product has certain linkages with the quality and reputation of that product. So if we talk about Darjeeling tea, so the word Darjeeling tea being a GI signifies that the tea is produced in Darjeeling and it has specific characters with regard to the quality and the reputation that has created by the tea over time. Okay. So these are the, the parameters which are essentially required to get registration under geographical indications. And we have a law under geographical indications wherein a patent for application can be filed by the association. Okay. Individuals, they are excluded from filing a patent application. It has to be a collective effort by an agency or an association which is working for the benefit of the stakeholders. Okay. So this is very important kind of tool which is being used for protection of the TK based TK based products which are available in our country. So these are some of the examples. So in left you can see the agricultural products. The Darjeeling tea, we have this Guntur chili, then turmeric, which are registered under GIs, and they are basically falling under agricultural category. Apart from that, we have certain products which naturally occur in the nature, and they are also registered like sandstone, it's Chunar Balwa Patthar, then Makrana marble of Rajasthan. These are some of the examples. And apart from that, we have a different category wherein the manufactured products, be it a handicraft, be it a industrial good or food stuff, they are being registered as GIs. So these are some of the examples of these GIs which are there. So as I talked about the characteristics of GIA, there must be a designated geographical area. Okay. So while filing the application for getting a GI registered, we have to give a map designating a specific geographical area from where the product originates. Okay. And in case it's a processed product, then at least one of the stage of preparation is happening there in that defined area. Okay. And it has to be a very much defined map. There must not be any confusion with regard to the demarcation of those areas. Okay. So once you identify the area under which that product is being produced, then you have to establish the reputation. Okay. That the product which is originating in that geographical location has a distinctive reputation that can be with regard to the nature of goods, with regard to the quality, or the repute that it has created domestic or globally, or it can have certain other characteristics which can establish the reputation of the product originating in that geographical area. Okay. Then another essential parameter that is to be followed is like you have to establish linkage with the product. Okay. So the given quality has a linkage with the agroclimatic conditions of the geographical location. So there must be a linkage between the reputation which has created or the quality that is there and with the location. So it can be, the quality, geographical location, the kind of raw material that is being sourced or the skills that exist in that area. Okay. So if you talk about Banarsi sarees, the kind of skill that people have gained over the time is one of the linkage that creates a reputation in those sarees. Okay. Apart from this, these essential characteristics, you must also establish the uniqueness. Okay. And apart from that, there are certain other requirements that are to be fulfilled while filing the application. And these are some of the text that you have to submit. So you have to establish the historical origin by way of ancient text or some kind of expert's opinion or some other evidences which can establish these parameters efficiently. Then only the registration is given for the GIS. So this was one of the examples wherein there was the disagreement between two states with regard to getting right over the Rasgulla. So we all know that Rasgulla is very famous in Bangla, this West Bengal, and it is also equally being used, or it's a sweet being used in Odisha. So they had a kind of disagreement while the applications were filed. So they claimed the qualities which have been given in this presentation So after that, it was found that these two products are completely different. They have different aroma, they have different color, the texture is also different, and the sweetness is also different. So after all the deliberations and discussions, it was decided that both, since these two products are completely different, therefore they should be registered separately. So now we have to know Rasgullas under that. So this is one of the examples wherein the TK based product is being used under GIs for certain additional uses. So if you know that Valli paintings, so Valli paintings, they are basically practiced in the state of Maharashtra. So these are the paintings which are basically done on the walls with white paste, and the traditional element in that is that the paste which is being used for making these paintings, they are made up of rice, water, and gum. So there is a specific way of making this paste, and the brush that is being used to paint these are like they create these brushes from the bamboo sticks after chewing. Okay, so there is a specific way of creating the paste and the brushes that they use, and basically what they create is like these paintings are made during certain celebrations. Okay, so like somebody is having marriage in their home, so they sing some no traditionally some folklores, and they just paint those things on the wall. So these are basically, these paintings are having certain stories imbibed in that. Okay, and they have specific motifs and specific way of making these. They have them, the people practicing these Valli paintings, they have their own way of making these paintings in a traditional way. Okay, so if you see the GI application which is filed before the GI registry, so basically these are practiced on the walls, but the application that has been filed, it is filed under 3 classes. It is like class 16, 20, and class 25. So basically, the rights which are asked under this GI application is like they will now be applied on paper under class 16, paper, cardboard, and plastic. And under class 20, they may be used on wood, plywood, furniture, and in class 25, they can be used on canvas, cloth, or garment. So it's a kind of combining the traditional thing into the modern requirement and making it happen. So the another GI, another IPR tool, that we'll be discussing is like plant variety protection. So we all know that new plant varieties, they are registrable under a sui generis law which is existing in nature, in India, for protection of these varieties. Okay, so the essential requirement of getting a plant variety registered is like it should be distinct from the it must be distinct, uniform, and stable in the expression. Okay, and basically this is targeted towards the agricultural sector. Okay, and when we talk about the legacy of this law, although the inspiration has been taken from the model draft of this International Union of Protection of New Plant Varieties of Plants, UPO, but we have provisions which are in addition to the model draft. Although we have not ratified or signed, we are not a part of this union, but still we have enacted the law which is sui generis in nature, having some plus provisions of the standard draft that has been prescribed by this agency. Okay, so the best part is like, apart from breeders, it gives right to the farmers also and researchers. Okay, so it's a kind of comprehensive law over the protection of plant varieties, which takes care of the farmers and researchers right as well. And these are some of the categories of variety which are protected under this Plant Variety Registration Act. So we can protect new plant varieties, we can have extant varieties also registered, we can have farmers variety registered under this law, and we can also register essentially derived varieties. So it gives the criteria which is essentially needed for the registration. It gives detail of the rights which are conferred on the owner of the right holder, and it gives the duration for which the protection can be given. So this, we will share these slides so you can go through in detail once we share these slides with you. Another important IPR tool which can be used for the protection of intellectual creations is like it's semiconductor integrated circuit and layout designs that. Okay. So basically, if we see the electronic items like we have computers or mobiles, there is a kind of design wherein you can see these integrated circuits, you can see some circuitry elements which are arranged in a specific way, and arranging these elements makes a product, I mean, very precious. You can appreciate the fact that a mobile phone is expensive than a computer system because the arrangement of these circuitry and integrated elements has reduced the size of that electronic item, which requires a certain degree of proficiency and intellectual input. Okay, so once you are investing in R&D of making these layout designs, there is an requirement of protecting those elements also. So under this law, you can protect the layout design which is there. Okay, so this is a law, although it is used very, it is out of, we don't find much applications being filed under this law, but the companies or the creators who know, they use it very efficiently to protect their chips and microchips. Okay, so this is basically the layout which is being protected. So it is not protecting the product as a whole, but the way these elements and circuitry designs, they are put on a map, this layout, it is being protected. Okay, so if you talk about the essential requirements of getting layout design registered, then it must be inherently distinctive and it must be capable of being distinguishable from the existing items. So these two parameters are like that. In its own, it must have a different identity. It must not be similar to others. Okay, and the second requirement which is there, that is capable of being distinguishable, is like it must be similar to the existing things. So it must have its own identity and it must not be similar to others also. In case it lacks these two essential parameters, then it is not registrable under the law. Okay, and the basic term that they have given is like originality. Okay, so it must be original in its expression, although we can combine two or more layouts to form a new layout which can become original in nature in case it has inherent distinctiveness and it is capable of being distinguishable from the existing two items. Okay, and another requirement is like that that the layout design should not be exploited before 2 years. Okay, so in case you develop something which is not used before 2 years, then you can establish the originality. It is not like that in case something is publicly available, it is not establishing the novelty. Okay, unlike patents. So, and if you talk about the duration of the rights granted under this law is like 10 years. You can get 10 years from the date of first commercial application or the date of application, commercial use or the date of application. Okay, so these, I talked about various types of IP tools that can be used for protecting your intellectual creation. So now if we summarize, we can very well see what kind of items can be protected and what are the examples. So it's very clear now that if we talk about copyrightable subject matters, then it includes literary, musical, and artistic works like a book or a sound recording. When we talk about patents, they are inventions basically involving technological developments. They may be vaccines or drugs. Then with regard to trademarks or collective marks, these are the signs being used as brands. Coca-Cola is one example. GIs, we already discussed the Darjeeling tea in detail. Then for industrial designs, the design of a basket that very well qualifies to be protected under industrial designs, and the protection is given to the aesthetic element of the product. Okay, nothing it's related to the functional parameters of that product. And with regard to layout of integrated circuits, the layout design of the chips that is being protected, and circuits we already discussed. And with regard to the plant varieties, the species Hansraj rice, a species, I mean, one variety of rice is protected and can be protected under plant varieties law. So this is a standard picture that we use. So when we talk about Coca-Cola as a product, it has certain IP elements in it. Okay. So the way this Coca-Cola has been expressed and that mark is being used for branding, that is a trademark. Okay. And the recipe that is being used to prepare this beverage is a trade secret, although we have not discussed because there is no specific law on it in India, but trade secrets can be protected by way of Contract Act. So we can have a non-disclosure agreement or confidentiality agreement with the people with whom we are sharing that information. Okay, so it's very difficult to protect it just because we don't have a legal instrument or a designated authority to grant rights under trade secret. All you have to do is like you have to protect your own rights and you have to just use the legal agreements for protecting it. Then this is a bottle opener, the design and the way it is being used and it is functioning, we can get a patent over it. The design of this bottle can be protected under design law. Then again, the method of opening this can itself was patented, and the labels that are being used on this bottle are copyrighted. So from this whole presentation, what we can infer is like there are certain conceptual similarities in IPR tools that we have. So basically, all these tools, they protect product or processes arising out of the creative intellectual activity of some people. Okay. And there is a specific criteria for each tool. Okay. We have seen that for patents, we need novelty, inventive step, and industrial applicability. However, for copyright, it must be original in its expression. Okay. So there are certain criteria for protection also. Okay. And they confer exclusive rights. So when we talk about patents, you get certain rights. Okay. You cannot, produce that. You cannot offer it for sale. You cannot import products which are patented. So there are certain specific rights granted under each IP tool. Okay. Apart from that, there are certain limitations and exceptions. When we talk about copyright, there is an exception for fair use. You can use copyrighted subject matters both for private and personal use, for research purpose, for educational purpose. So they are, those activities are exempted from infringement. Okay. And we have also seen that these all IP tools, they are limited in time. Patents are for 20 years. Then we have trademarks 10 years, which you keep and renew further. So they have a limited time. Okay. And if we talk about the differences or dissimilarities, then we have different parameters for assessing the subject matter. Okay. So when we talk about patents, it's like the technological inventions, they are covered under it. If we talk about industrial designs, then the appearance of the articles that is protected. If you talk about the copyrights, then the literary work or the sound recordings. So the subject matter of each IP tool is different. Then requirements of grants are also different. Conditions are completely different. And the nature of rights are also, they differ in a way. And duration, as we talked, they are completely different. So to summarize, we can use these IPR tools to protect the creativity and inventions that we come across. Okay. So in case we are investing resources for developing a new item out of our creativity, then it must be protected so that improper or unfair use is not happening. Okay. So somebody can copy it in case you have not protected your creation properly under this specific tool. So it's very much required to protect your inventions from invention and creative items from being misused. Okay. And apart from that, you get commercial reward. You can reap out the benefits, commercial commercial benefits out of the efforts that we have made. And we have also seen that some of the tools, they are being used as branding. They can be used for branding, okay? Like trademarks and GI. Basically, they are consumer centric. So you may use these tools to make the consumer aware that this is your product. And in case you are not finding these marks or indications on the product, they come from a different user. So in a way, you're protecting the rights of consumers also and gaining a goodwill in that product. And it's very essential. I mean, it is essentially required to have a healthy competition in the market. Okay. Basically, what other things that we can take is like your ideas, if your creative ideas can be converted into workable assets. Okay. So you can have economic benefits in case benefits once you protect your ideas or creative activities under proper tool. And most important, they boost innovation. They give additional edge over, I mean, to you over the competitors. They enhance your business potential, and no doubt, it creates a brand in the society. So with this, I thank you all, and now I will stop sharing my slides. So we can have questions. Yoshi, am I audible?
Anil, we can put the link, I think, for the
Okay.
assessment, and then after that we can take up questions.
Yes, madam. I just So we request all of you, all the participants, please submit your assignments before 10 minutes. It's 4:40. Before 4:50, please submit your assignment. Please submit your assignment. Time is over. Madam and sir, can you start the question and answer session?
Yes, please.
Arya is here. I request you to say some few words. I request Arya.
Namaste. Namaste and namaste and welcome to the entire group of participants. I hope you've been able to do the assignment successfully. I was able to hear in and out Anilji's session. Should we open it up to the question and answers? Would you like us to read them out? Huh? Anilji?
Yes, yes.
Or we can request our participants, please raise your digital hand. If you have any questions, we can unmute and you can speak your question.
Design can raise their names perhaps.
Yes. Sheetalji, could you please ask your question?
Good evening, ma'am. May I audible to everyone?
Yes, yes, you are audible. Please,
Yes.
please.
Good evening, ma'am. My question is that what is the difference between design patent and patent? And how by design, if you are going for patent, it is used to grant after a long period of time, but design patent is granted very soon. So how it is possible, and can you give some inputs on this?
See, in India, I will talk about the law which is in India. Okay. So patent is a different domain governed by a different law. Okay. And design is a separate regime which is governed by a separate piece of law. So in India, Indian Patent Acts, it governs the patents which is granted for the technological inventions that we make. It is directly linked to the technology. Okay. However, if you talk about designs, these are the basic designs that we see. Okay. So if you see a mobile, it has both elements in it. The technology that is in the mobile can be protected under Patents Act. However, the appearance of the mobile, which we see from our eyes, that is a design which can be protected under Designs Act. You got the difference? So you have just combined both. However, they are different in nature. They have different regime for protection and they have different criterias for protection also. I hope I could answer your question. And another question was like, why there is a delay? Okay. So with regard to patents, we have a very detailed process of examining patent applications. So we have to see the invention that has been filed vis-a-vis the state of art which is available. So we have to assess the novelty parameter. We have to assess the inventive step also. We have to see whether it is obvious or not. It has industrial application. So it's a very detailed examination that happens, which is done by a person who is expert in that field. Okay. However, the examination process in design is different. Okay. So there is not so much of deliberations put in. So might be this is one of the reasons we get a design faster than the patents.
Namaste, Vikramji.
Yeah,
Could you
pranam,
please ask
pranam.
your question?
Yeah, is my voice is audible, sir?
Yes.
Yeah, okay. Is it sound clear? Okay, sir, I just want to know one answer question from you. How the Indian standardization of patents are manageable according to the international standard? For example, if I have done some kind of patents in India and same patent somebody else has done in the different name, but the internal contents are same, then how we can manage that the internal content is been properly done in a right way in India is not been matchable in the international standards?
See, with regard to the standards of getting patent, so the regime of intellectual property rights, it is governed by an international organization, which is WIPO. Okay, so they prescribe the certain standards which jurisdictions, I mean, all the states, they have to follow who are signatory or part of that organization. But considering the domestic conditions or the requirements of a country, there are certain limit, I mean, certain privileges given to them. For example, for India, we are based on agriculture. Okay, so we have some plus measures which restrain getting a patent over the methods of agriculture or something. I'm just giving an example. So we have some kind of restrictions put in with the vis-a-vis our economy that exists in our country. Okay, so first question was, what are the standards? Is like we have basic standards are same. However, we have some plus or minus measures in all the countries. Okay, and with regard to the specifications filed, these patent applications, they are examined very specifically. Experts, they examine them. So it's a process of getting them examined, and they do it very well vis-a-vis na. I mean, the standard of that. I mean, rather I should say, the state of art which exists outside country. So for examination of patent applications, the standard is global. They can refer to any document which exists in other jurisdiction also. Okay, so this is how, I mean, these things are being done.
Yeah. Thank you so much. But one thing I like to know that an international standard, for example, there is a difference of 10 to 15 days in the same intelligence which a person is working. Content is same, but idea of demonstration activities are different, but the internal contents are same. And the registration first has been taken place with the international company, but according to Indian, you are 10 days late.
So it's a different, I mean, aspect that you
think,
have
Mr.
touched.
Vikram, the difference here when you're talking of a grant of a patent, timelines has got nothing to do with the, the quality of the patent grant, because once you apply for the examination of your application, and depending on, what are the national jurisdictions that you choose, your patent application will be processed further. Okay, and the criteria for a patent grant that Anil had also mentioned is three major criteria. One is the novelty, the second one is the inventive step, the third one is the applicability or industrial utility. So these, when you're talking of these three criteria, they have been well defined. Okay, and we follow the TRIPS agreement. In fact, what Anil mentioned is all about that. When we follow the TRIPS agreement, there are minimum standards prescribed. Over and above the minimum standards, nations can have their own national legislations and provisions to protect national interest. So that is how it is done. So if in case your application is filed today here in India and there is a particular application of similar nature that has been filed either in the US or Europe, okay, the novelty and inventive step is dependent on the prior art. So your grant The patent grant in India will depend on whether that particular application has got a priority date before or after your application.
Yeah, I understand that. Yeah. Thank you so much. Yeah.
Thank you.
Anilji, I'll just ask you a question from the written chat, from the chats. There's a Dr. R. Bharandharan who's saying, can we file a case if someone took our article and got copyrights in their name?
Yes, definitely. There are provisions. So in case somebody is copying your work, then he is infringing your rights, and you can very well know first intimate that person to stop that infringement. In case he is still continuing with that, you can go for an infringement suit before the competent court. So that is possible.
Supposing they have already published it, then how does one reclaim that, the ownership? How does one establish that you're the first author?
They have to withdraw.
No, how you have to first establish that you were a prior thing. So one would have to have published it earlier on, and then somebody has
Yes.
taken it and copyrighted it. Okay, so
In fact, the copyright law says your rights start when you publish. Okay. So the moment you publish, you have a copyright in it.
Namaste, Dr. Indu. Could you please ask your question?
Namaste, sir. Good evening, sir. Sir, I have a question. If we have a technology thing developed and we want to take a utility patent, so is there an issue if we take a design patent also along with it?
See, in India, we don't have the concept of utility patent. Okay, so you have to file a proper patent in case it has technological aspect, as we discussed. For design, you have to take recourse of the design law that we have, but that will give you protection over the physical appearance, the design that is visible through eyes. Patent is for
kind
the
of,
technical
yeah, that's
purpose.
the example that Anil had given. So when you talk of a mobile phone, you don't need to restrict yourself to taking only one type of intellectual property rights. You can have patents on, whatever is the material that is used or the technology that is used. In terms of the software, you can take a copyright in India. In terms of the 2D or the 3D structure design, you can take a design. What are the other two? Semiconductors. Okay, semiconductor
Semiconductors. We
circuits.
can get a registration over the layout design.
Yes, you can have a
And
trademark.
trademarks.
Yes,
And
you can have
trademarks,
a
the brand.
trademark also. So when we are talking of any kind of intervention or technological invention that we create, there are multiple aspects of intellectual property rights that one can apply for.
thank you. There's another question by Furkan Saifji who's saying that if we copy someone's trademark, what are the illegal charges that one can face?
See, first, if you infringed the rights, trademark rights of somebody, then the kind of payment that you have to make depends, because one is like you have made some losses to that person. So that is one part. He may say that I had certain degree of loss that I have incurred, so that you have to pay. Apart from that, there is a concept of compensation and penalty also. So the amount may go very high also in case you are copying a brand which is well established and has a higher degree of revenue being generated in the market. So it depends on the circumstances of the case. There is a formula which is being used by the courts while deciding the compensation.
Namaste, Dr. Manoj ji. Could you please ask your question?
Hello. Is my voice audible, sir?
Yes, please proceed.
Sir, my question is, suppose that I have written an article. So what are the processes we can follow, sir, get my article as a copyright, sir?
The beauty of copyright law in India is you don't need a formal registration of the authored article. Okay. So in case you have published an article, be any platform. So once you publish, you get the right at the point of publication itself. So this is one way of getting rights. Another way of getting right is like you can get a formal registration before the copyright board. Okay. So
Okay.
in that scenario, you have to disclose the date of publication in your application. So there also you will get a certificate which will state that the first date of publication was this date. Okay. So you will get a formal certificate in that scenario, which will be a prima facie evidence of getting a right. Okay. So it is very useful in the sense that when you state that somebody is infringing my rights, so you will have a certificate which in a way establishes that you are the owner. However, in case you have not get the certificate, then you have to first prove that you are the owner by way of certain evidences. So protection starts the moment you publish, but getting the registrations help to get enforcement in a better and proper way.
Thank you, sir. Thank you, sir. Thank you.
Lokesh Kumar sir is saying, sir, can we patent our assessment tool or checklist which we prepare for assessing individuals with disabilities or disorders? So assessment tools.
Tools that sir is speaking about, in case it has some technological intervention, okay, it falls within the definition of invention, then definitely they can get a patent. In case they want to protect the design aspect, then design law is there. So it's all about like, in case it's functional in nature and it has technological intervention, fulfilling all the requirements of getting a patent, it can be patented, yes.
सर सादर प्रणाम, आवाज आ रही है सर? हेलो सर, आवाज आ रही है मेरी?
Yes, please proceed.
सर मेरा दो प्रश्न है। पहला प्रश्न ये है कि सर कॉपीराइट का जो वायलेशन भारत में होता है, चूंकि मैंने देखा है खुद की इससे आज़ादी से पहले चूंकि बहुत सारे यूनिवर्सिटी की स्थापना हो चुकी थी, तो जो सीनियर प्रोफेसर या जो हमारे यहाँ से BHU की स्थापना 1916 में हुई थी, तो एक हमारे सर प्रोफेसर AK चटर्जी सर हैं या और भी जो सर हैं लोग, उनके आर्टिकल चूंकि उन्होंने उस समय कॉपीराइट था नहीं, और अभी देखते हैं प्रेजेंट टाइम में जो है जो लोग हैं वो लोग उन्हीं के आर्टिकल को एज इट इज उठा के और अपने यहाँ जो है अपना आर्टिकल दे के और पब्लिश करा लेते हैं। तो सर इसके लिए कोई प्रावधान है कि नहीं? और सर दूसरा चीज़ ये है कि जैसे ट्रेडमार्क की आप बात कर रहे हैं, तो जो बड़ी कंपनियां हैं जैसे कोका कोला की आपने बात किया, तो प्रसून जोशी सर ने 3 करोड़ रुपए दिए थे कि ठंडा मतलब कोका कोला, लेकिन सर छोटे जो उत्पादक हैं जैसे आपके आगरा का जो पंछी पेठा है, तो उसके नाम से अगल बगल तमाम पंछी पेठा खुल गए, और उसका जो मेन जो उसकी शॉप थी उसके यहाँ लोग दिग्भ्रमित हो जाते हैं, दूसरी जगह से ले लेते हैं, तो उनके अधिकारों की रक्षा कैसे हो?
देखिए, जब कॉपीराइट की आप बात करते हैं तो पहला पैरामीटर ये है कि क्या जो मैटर है वो कॉपीराइट प्रोटेक्टेड है। तो उसमें ये है कि इट मस्ट बी ओरिजिनल। आपने कहा कि प्रोफेसर साहब थे, उनका आर्टिकल है, तो इट वाज ओरिजिनल, वही चीज स्टैब्लिश हो गई। दूसरी चीज है, आप बोल रहे हैं उसको यूज किया जा रहा है, तो यूज करने के लिए आप देखिए कि आप वो उस ड्यूरेशन में ही हम उसका इन्फ्रिंजमेंट कर रहे हैं। तो जो ड्यूरेशन है कॉपीराइट का, दैट इज लाइक 60 years स्टार्टिंग फ्रॉम द 1st of January व्हेन द ऑथर डाइज। नेक्स्ट ईयर से उनके होगा, है ना। तो अगर मैंने आज कोई आर्टिकल लिखा है तो मेरे लाइफ टाइम में वो इन्फोर्स रहेगा, और मेरी डेथ 60 years, मेरी डेथ के 60 years बाद तक चलेगा, जो 1st January फ्रॉम द नेक्स्ट ईयर मेरी डेथ के शुरू होगा। तो अगर वो उस दौरान हो रहा है तो यू कैन क्लेम इन्फ्रिंजमेंट, ठीक है। तीसरा चीज ये है कि वो जो कॉपी हो रहा है क्या उसमें प्रॉपर एट्रीब्यूशन हो रहा है। इन केस वो प्रॉपरली एट्रीब्यूट कर रहे हैं कि उन प्रोफेसर साहब का ही हमने आर्टिकल है, वो इतना हमने लिया है, ठीक है, तो इट्स अ काइंड ऑफ फेयर गेम दे आर डूइंग। दूसरा, एग्जेम्पशंस आपको देखने हैं, क्या वो एजुकेशन पर्पस है ना, क्या वो रिसर्च पर्पस के लिए यूज कर रहे हैं, वो एग्जेम्प्टेड कैटेगरीज है अंडर सेक्शन 51 ऑफ कॉपीराइट एक्ट, तो वो भी आपको देखना है। इन दैट केस यू कैन नॉट क्लेम। तीसरा, हो सकता है उन्होंने परमिशन ली हो, जो भी प्रोफेसर हैं या उनके जो भी लीगल आयर्स हैं
जी
उनसे परमिशन ली होगी तो भी वो कर सकते हैं। तो ये सारे पैरामीटर्स हम लोगों को देखने होते हैं बिफोर एस्टैब्लिशिंग दैट देयर इज एन इन्फ्रिंजमेंट, है ना।
हाँ
And
सर,
then
जो
just
तीसरा
one small
तीसरा
added to this is plagiarism. Okay, even if say the original author has given you permission,
yes,
you cannot copy paste exactly the same matter. So you
okay.
have UGC guidelines on plagiarism. There's a gazette notification. Please read that, because you cannot plagiarize any material. Even in terms of research articles, when we publish in journals, we transfer our copyright to the publisher. Okay, so you sign the copyright form so that your particular article is taken, the copyrights are taken by the publisher. So these are all some subject matters that needs to be considered, especially in the academic forum, because not everything becomes our own rights, even if the research is done by us. So once you publish the subject matter, to whom you have given the rights, how you have given the rights, what is copyright and what is plagiarized material, all these needs to be taken into consideration of.
Thank you, ma'am. Thank you, sir.
We were wondering, it's already 5:15. So what would you suggest? There are a lot of questions, which is actually very enthusing because so many people want to know more, and I guess there's a great demand for these sessions. So what do you suggest, please?
We'll stop here, Anuradha, because many people would like to leave. It's on more than 1.5 hours, so we'll stop here. Because the next 2 days also we'll be covering many of the IPR aspects, especially in the context of traditional knowledge. I think we can take up some of the questions then.
Yes, and those who have some questions and all, I think your email addresses are also shared. They can directly write to Anilji or the respective speaker of the session and get the answers. So thank you very much, those who have participated, and with all your enthusiasm. It's very encouraging for us to want to keep doing these courses more and more. So with these few words, we can close here for today. And I'll end with a Shanti mantra. In these times of great uproar in different corners of the world, this would be very important. So please join me if you are, if you know the one. Om Sarve Bhavantu Sukhinah Sarve Santu Niramayaha Sarve Bhadrani Pashyantu Ma Kaschid Dukha Bhag Bhavet. Om Shanti Shanti Shanti. So just for those who have joined, this is just a prayer that says, Sarve Bhavantu Sukhina, may everybody be happy. Sarve Santu Niramayaha, may everybody be without disease. Sarve Bhadrani Pashyantu, may everybody see good things and be inspired by good things. Ma Kaschid Dukha Bhag Bhavet, let nobody have any sorrow. So thank you very much for being part of this ongoing IKS and TKDL efforts. Thank you very much. See you tomorrow. Thank you, Anilji. Thank you. Thank you, Mr.
Namaste.
Namaste.